Chapter 1. The General Concepts and Principles. Section 1. This act shall be known as the Cooperative Code of the Philippines. Section 2 is all about the Declaration of Policy, which outlines the state's policy on promoting cooperatives as a means to achieve self-reliance, economic development, and social justice. It encourages the private sector to actively form and organize cooperatives and aims to create a supportive environment for their growth. The government is committed to providing technical guidance, financial support, and other services to help cooperatives become successful and autonomous enterprises. Under Section 3, we have general concepts. It defines a cooperatives as a legally registered group of people who share a common interest. These individuals voluntarily come together to achieve a lawful social or economical goal, contributing fairly to the capital needed and sharing the risks and benefits according to established cooperative principles. Section 4, we have cooperative principles. It outlines the principles that guide the operation cooperatives. Number 1, open and voluntary membership. Membership is open to all individuals regardless of background and is voluntary. Second, democratic control. Cooperatives are governed democratically with members having equal voting rights, ensuring fair representation. Third, limited interest in capital. The interest paid on capital contributions is strictly limited to prevent excessive returns. 4. Division of net surplus. Profits are shared among members for cooperative development, common services, reserves, and other benefits as specified in the cooperative rules. 5th, cooperative education. Cooperative must provide education for members, officers, employees, and the public about cooperative principles. Cooperation among cooperatives. Cooperatives should work together at all levels to better serve their members and communities. Chapter 2, Organization and Registration. Section 6, Organization of Cooperatives. These outline purposes of which a cooperative can be organized and registered. A cooperative can be formed by at least 15 people to first promote savings and thrift among members. Second, raise funds and offer credit to members for productive or provident needs. 3. Support systematic production and marketing among members. 4. Provide goods, services, and other necessities to members. 5. Develop skills and expertise within the membership. Section 7, we have objectives of cooperatives. This defines the primary objective of a cooperative, which is to provide goods and services to its members, helping them increase their income, savings, investment, productivity, and purchasing power. It aims to promote fair distribution of profits through economies of scale, cost sharing, risk sharing, without being a focus on charity. Section 8, Cooperative not in restraint of trade. In this section, it clarifies that cooperatives, as long as they operate in accordance with this code, will not be considered illegal or anti-competitive. Specifically, they will not be seen as engaging in conspiracies to restrict trade from illegal monopolies or manipulate prices in violation of Philippine laws. Section 9, Cooperative powers and capacities. In this section, it outlines the powers and capacities of a cooperative registered under this code. First, the cooperative can initiate or defend legal action in its own name. It has the capacity to continue its existence over time. It can amend its articles of cooperation as per the provision of this code. And last, it can adopt, amend, or repeal bylaws as long as they are not contrary to law, morals, or public policy. Section 10. Organizing a primary cooperative. In this section, it states that a primary cooperative can be organized by at least 15 Filipino citizens who share a common interest and live or work in the area where the cooperative will operate. Section 11, Economic Survey. In this section, it requires any group or cooperative planning to form a new cooperative to submit an economic surveys to the Cooperative Development Authority. This survey should include a description of the proposed cooperative structure, purposes, economics, viability, area of operation, membership size, and other relevant information. Section 12, Liability. A cooperative shall be registered under this code with limited liability. Section 13, Term. It states that the cooperative can exist for up to 50 years from its registration date unless it is dissolved earlier or the period is extended. The cooperative's term can be extended for up to 50 years at a time through an amendment to its Articles of Cooperation. However, extensions cannot be made earlier than 5 years before the current terms end, unless justified reasons are provided as determined by the Cooperative Development Authority. Section 14, Articles of Cooperation. In this section, Article of Cooperation states that cooperatives seeking registration must submit their Articles of Cooperation to the Cooperative Development Authority. These documents must be signed by all the cooperatives organizers and acknowledged by them. If the organizers are individuals, their signatures must be notarized. If the organizers are legal entities, the documents must be signed by the president or secretary of the entity, and the signature must also be acknowledged before a notary public. Section 15, Bylaws. In this section, it requires that every cooperative seeking registration must adopt bylaws that are consistent with the provisions of the applicable code. These bylaws must be filed with the Cooperative Development Authority at the same time as the Articles of Cooperation. Section 16, Registration. In this section, it outlines the process of registration for cooperatives. A cooperative gains juridical personality or legal recognition once the Cooperative Development Authority issues a certificate of registration under its official seal. Section 17, Certificate of Registration. In these sections, it states that the certificate of registration issued by the Cooperative Development Authority, bearing its official seal, serves as conclusive proof that the cooperative is properly registered. This certificate is valid until it is shown that the cooperative registration has been cancelled. Section 18, Amendment of Articles of Cooperation and Bylaws. In this section, it allows for the amendment of the Articles of Cooperation and Bylaws of a cooperative. To amend any provision, a two-thirds vote of members with voting rights is required provided the amendment serves as a legitimate purpose. Dissenting members have the right to withdraw their membership under Section 31 and 32. The original and amended articles must include all illegal requirements. Amendments must be clearly indicated and accompanied by a sworn certification from the cooperative secretary and majority of the directors confirming approval by the required vote. Section 19, Contracts executed prior to registration and effect thereof. In this section, it states that contracts made between a private person and a cooperative before its registration remain valid and binding once the cooperative is officially registered. However, a formal written contract must be made in the cooperative's names or on its behalf before the cooperative is registered. Section 20, Division of Cooperatives. In this section, it allows a registered cooperative to divide into 2 or more cooperatives through a resolution passed a 2/3 vote of eligible members at a General Assembly. The process for division is outlined in the Cooperative Development Authority regulations. The newly formed cooperatives are legally established upon registration with the authority provided they meet all legal requirements. Section 21, Merger and Consolidation of Cooperatives. In this section, it outlines the process for the merger or consolidation of cooperatives. First, we have merging cooperatives. If 2 or more cooperatives can merge into one cooperative, which will become the consolidated cooperative. Second, approval process. The merger or consolidation requires the approval of 2/3 of the voting members of each cooperative at separate general assembly meetings. Dissenting members have the right to withdraw their membership accordance to Section 31 and 32 of this law. Third, guidelines and effectiveness. The Cooperative Development Authority will provide guidelines for the merger or consolidation process. The merger or consolidation becomes effective once the Cooperative Development Authority issues the certificate of merger or consolidation. Section 22, Effects of Merger and Consolidation. In this section, it explains the effects of a merger or consolidation of cooperatives. First, the constituent cooperatives will become a single cooperative, which will either be the surviving cooperative or the consolidated cooperative. Second, the individual existence of the constituent cooperatives will end, except for the surviving or consolidated cooperative. Section 23. In this section, it outlines the different types of cooperatives. First, credit cooperative aims to encourage thrift among its members and create funds to provide loans for productive and provident purposes. Second, consumers cooperative. Its primary purpose is to procure and distribute commodities to both members and non-members. Third, producers cooperative focuses on joint production activities, either agricultural or industrial, by its members. Section 24, Federation of Cooperative. It allows for the registration of Federation of Cooperatives, which consists of primary and secondary cooperatives engaged in single-line or multipurpose business activities. The federation can be registered under the code for any or all of the following purposes. Section 25, Cooperative Unions. In this section, it allows registered cooperatives and federations to organize or join cooperative unions at various levels, either provincial, city, regional, and national. These unions aim to represent the interests and welfare of all types of cooperatives. Chapter 3, Membership. Section 26, Who may be members of cooperatives. In this section, it outlines the members who will be the members of a cooperative. Natural persons who are Philippine citizens, as well as cooperatives or non-profit organizations with juridical personality are eligible for membership if they meet the qualifications set in the cooperative's bylaws. However, only natural persons can be members of a primary cooperative. Section 27, it outlines the kinds of membership in a cooperative. First, regular members. These members are entitled to all rights and privileges of membership, including the right to vote and be elected. Second, associate members. These members do not have voting rights or the right to be elected, but they are entitled to only the rights and privileges specified in the cooperative's bylaws. Additionally, a cooperative organized by minors is classified as a laboratory cooperative. It must be affiliated with a registered cooperative and will be governed by special guidelines set by the Cooperative Development Authority. Section 28, Government Officers and Employees. In this section, it addresses the eligibility of government officers and employees in relation to cooperatives. First, Cooperative Development Authority. Officers and employees are disqualified from being elected or appointed to any position in a cooperative. Second, elective government officials, except for barangay officials, and are ineligible to serve as officers or directors of cooperatives. Third, government employees may be allowed by their department heads to use their official time for attending General Assembly meetings, board meetings, seminars, conferences, workshops, and training courses related to cooperatives, both locally and abroad, as long as it does not negatively affect the operations of their government office. Section 29, Application. It outlines the process for membership application in a cooperative. First, an applicant becomes a member after the board of directors approve their membership and can exercise membership rights once they have made the required payments or required the necessary interest as specified in the cooperative bylaws. Second, if the board of directors refuses or denies the membership, the applicant can appeal the decision to the General Assembly, whose decision will be the final. Section 30, Liability of Member. A member shall be liable for the debts of the cooperative to the extent of his contribution to share capital of the cooperative. Section 31, it outlines the process for termination of a membership in a cooperative. First, a member can withdraw their membership for any reason by giving a 60-day notice to the board of directors. Second, upon withdrawal, the member is entitled to a refund of their share capital contribution and other interest in cooperative. Third, however, the refund will not be made if it would cause the cooperative assets to fall below the total of its debts and liabilities, excluding the withdrawing member's share capital contribution. Section 32, Refund of Interest. In this section, it stipulates that any amounts owed by a cooperative to a former member, as determined by the cooperative bylaws, must be paid either by the cooperative itself or by an approved transferee in accordance with the provision of the code. Chapter 4, Administration. Section 33, Composition of the General Assembly. It defines the composition of the General Assembly of a cooperative. It consists of members who are entitled to vote as specified in the Articles of Cooperation and Bylaws of the cooperative. Section 34, it establishes the General Assembly as the highest policy making body of a cooperative. It exercises the powers outlined in the code, the Articles of Cooperation, and the bylaws of cooperative. The General Assembly has certain exclusive powers that cannot be delegated to any other uh, to any other body, though the specific powers are typically listed in the following sections. Section 35, Meetings. It outlines the requirements for meetings of the General Assembly. First, a regular meeting must be held annually on a date specified in the bylaws, or if it not specified, within 90 days after the end of the special of each fiscal year. Second, written notice of the regular meeting must be sent to all members at their official addresses at least 2 weeks before the meeting, unless the bylaws specify a different notice period. Section 36, Quorum. Unless otherwise provided in the bylaws, a quorum shall consist of 25% of all members entitled to vote. Section 37, it explains the voting system for cooperatives. First, each member of a primary cooperative is entitled to 1 vote. Second, a secondary or tertiary cooperative can vote as a delegate for its member cooperatives, but it is limited to 5 votes. The votes cast by the delegates are considered as the votes of the members of the secondary or tertiary cooperative. Section 38, it outlines the composition and terms of office for the board of directors of a cooperative. First, the board of directors is responsible for the conduct and management of the cooperative affairs. Second, the board shall consist of at least 5 and no more than 15 members who are elected by the General Assembly. Third, directors serve a term specified in the bylaws, but the term cannot exceed 2 years. They hold office until the successors are elected and qualified or until they are removed. 4. No director can serve for more than 3 consecutive terms. Section 39, it outlines the powers of the board directors. The board is responsible for directing and supervising the cooperative's business and managing its property. The board can exercise all power of the cooperative except those that are specifically reserved for the General Assembly as stated in the Code and the Cooperative's bylaws. Section 40, Directors. It specifies the eligibility requirements for a director of a cooperative. First, a member is eligible to elected as a director if they have the right to vote as per the cooperative's bylaws, meet all the qualifications and none of the disqualification outlined in the laws of the cooperative's bylaws. In Section 41, it states that regular meetings of the board of directors for every cooperative must be held monthly unless the cooperative bylaws specify a different schedule. Section 42, it explains how a vacancy on the board of directors is handled. First, if a vacancy occurs, except due to their expiration of a term, it may be filled by a majority vote of the remaining directors, provided they still form a quorum. Second, if the remaining directors cannot form a quorum, the vacancy must be filled by the General Assembly in a regular or special meeting called specifically for this purpose. Third, a director elected to fill a vacancy will serve only for the unexpired term of the predecessor who left the position. Section 43, it outlines the roles and requirements for officers in a cooperative. First, the board of directors will elect the chairman and the vice chairman from among its members. 2. Other cooperatives officers can be elected or appointed from outside the board as specified in the cooperative's bylaws. 3. All officers serve during good behavior and can only be removed for cause after a proper hearing. Loss of confidence is not a valid reason for removal unless it is based on a specific acts or omissions that cause doubt about the officer's honesty and integrity. Section 44, Committee of Cooperatives. In this section, it allows the creation of an executive committee within a cooperative. First, the bylaws of the cooperative may establish an executive committee which is appointed by the board of directors. 2. The executive committee will have the powers and duties delegated to it either in the bylaws or by a majority vote for all the members of the board of directors. Section 45, Functions and responsibility of directors, officers, and committee members. The function and responsibilities of the directors, officers, and committee members shall be as prescribed in detail in the bylaws of a cooperative. Section 46, Liability of directors, officers, and committee members. The directors, officers, and committee members will be held jointly and severally liable for any damages or profits resulting from their action if they willfully and knowingly approve as assent to unlawful acts, are guilty of gross negligence or acting in bad faith while managing the cooperative affairs, acquire any personal or pecuniary interest that conflicts with their duties as directors, officers, or committee members. This liability extends to the cooperative, its members, and any other affected parties. Section 47 outlines the compensation for directors of a cooperative. First, if the bylaws do not specify compensation, directors will not receive any compensation except for a reasonable per diem for their attendance at meetings. Second, any compensation beyond per diems can only be granted by a majority vote of members with voting rights. No additional compensation other than per diems may be paid to directors during the first year of a cooperative existence. 48. Dealing of directors, officers, and committee members. It specifies the condition under which a contract between a cooperative and its directors, officers, or committee members is valid. First, a contract between the cooperative and any of its directors, officers, or committee members is voidable at the option of the cooperative unless all of the following conditions are met. First, the contract is authorized by the cooperative. The interested director, officer, or committee member discloses the nature of the interest in the contract. The contract is approved by a majority vote of the members with voting rights at the General Assembly meeting. And this safeguards ensures transparency and prevent conflicts of interest in transactions involving cooperative leadership. 49. It addresses the disloyalty of a director in a cooperative. First, a director who thought their position acquires an opportunity that should have belonged to the cooperative is liable for damages. Second, the director must refund double the profits that the cooperative would have earned from the opportunity unless the action is ratified by a two-thirds vote of all members with voting rights. This rule applies even if the director used their own funds in the venture, meaning their personal investment does not absolve them of responsibility. This provision ensures that directors act in the best interest of cooperative and are held accountable for any personal gain derived from opportunities that rightfully belong to the cooperative. Section 50. It addresses the illegal use of the confidential information by directors or officers of a cooperative. First, a director, officer, or their associate who uses confidential information related to the cooperative shares or debt obligation for personal gain or the benefit of an associate shall be held liable if the information, if made public, would likely materially affect the value of the cooperative's share or debt obligation. This provision seeks to prevent insider trading and ensure the directors and officers do not exploit confidential information for personal or financial advantage. Section 51, it outlines the provision for the removal of an elective officer, director, or committee member in a cooperative. First, an elective officer, director, or committee member may be removed by a two-thirds vote of the voting members present and constituting a quorum during a regular or special general meeting called specifically for this purpose. Second, the individual facing removal must be given an opportunity to be heard at the meeting before the vote takes place, and this ensures due process and fairness in removing cooperatives leaders. Section 52, Address. Every cooperative shall have an official postal address to which all notices and communications shall be sent. Such address and every change thereof shall be registered by the Cooperative Development Authority. Section 53, Books to keep open. In this section, it ensures transparency and accountability by allowing members and authorized officials to inspect the cooperative's operations and financial records. Section 54. In this section, it requires every cooperative to prepare and submit an annual report. First, every cooperative must prepare an annual report of its activities and financial status as of the end of the fiscal year. Second, the cooperative must publish the report and provide copies to all of its members of records. 3. A copy of the report must be filed with the Cooperative Development Authority within 60 days after the end of the fiscal year. 4. The form and content of the report are crucial as failing to comply with the prescribed requirements could lead to the revocation of the cooperative's cooperating authority. And in this section, it ensures transparency and accountability by requiring cooperatives to disclose their activities and financial health to both members and the regulatory authority. In section 55, it establishes the register of members or list of shares maintained by a cooperative as prima facie evidence. First, any register or list of members or shares kept by a registered cooperative shall serve or prima facie evidence of the following details entered in it: the identity of the members of the cooperative, the number of shares held by each member, other relevant membership or share-related details, and this means that the register or list is presumed to be accurate and can be used as evidence in legal matters unless proven otherwise. In Section 56, this provision ensures that records maintained by the cooperative are legally recognized and can be used as reliable evidence in legal proceedings. Section 57, in this provision, it is designed to safeguard the cooperative's assets by holding individuals accountable for their actions through the bonding process. Section 58, this provision gives cooperatives a legal right to secure their loans by claiming certain assets produced or acquired by the borrower using cooperative funds, ensuring the cooperative financial interests are protected. Section 59, this provision enables cooperatives to collect debts from members efficiently through automatic deductions from their earnings, even if other laws might generally prevent such deductions. Section 60, in these provisions, ensures that the cooperative can prioritize recovering debts owed by a member by claiming the member's capital, deposits, or interest before other creditors. Section 61, it outlines the tax treatment for cooperatives. First, cooperatives registered under this code that do not engage in business with non-members or the general public are exempt from government taxes and fees imposed under internal revenue laws and other tax laws. Second, the cooperatives that do engage in business with non-members or the public or do not meet the above criteria will be subject to the tax regulation outlined in the following section. And in this provision, incentives cooperatives to focus on serving their members by offering tax exemptions if they do not engage in external business activities. In this section, it aims to support cooperatives in expanding their business operations beyond their membership base while still granting them significant tax benefits to promote their development and sustainability. The specific exemptions for dealing with non-members would likely be detailed in the following provision of the Code. Section 63. This section ensures that cooperatives have special benefits or exemptions designed to support their operation, fostering their growth and empowering them to fulfill their role in the economy. These privileges typically aim to help cooperatives function effectively, possibly including tax benefits, preferential treatment in government contracts, or access to specific financial reports. Section 64, it addresses the insolvency of a cooperative. First, if a cooperative is unable to meet its obligations due to insolvency, it can apply for remedies under the Insolvency Law Act No. 1956 as amended, which governs how to handle financial distress and debt issues. Second, despite the cooperative's ability to apply for remedies, creditors are still allowed to seek protection and legal recourse under the insolvency law if necessary. In this section, it ensures that both the cooperative and its creditors have legal avenues to address financial difficulties in an organized manner in line with the established insolvency procedures. Section 65, it provides the process for voluntary dissolution of a cooperative when no creditors are affected by the dissolution. First, we have approval process. Board of Directors. The board must be approved the dissolution. General Assembly. At least 2/3 of all members with voting rights must then approve the dissolution of a General Assembly meeting. Second, notice requirements. First is the publication. The meeting must be announced for 3 consecutive weeks in a local newspaper or a general circulation newspaper if none is available locally. Direct notice. A notice must also be sent to each member by registered mail or personal delivery at least 30 days before the meeting. Third, resolution. Once the dissolution is approved, a certified resolution must be signed by the majority of the board directors and countersigned by the cooperative necessary secretary. Number 4, certificate of dissolution. After the proper procedure is followed, the Cooperative Development Authority will issue the certificate of dissolution. And in this section, it ensures the dissolution process is transparent, includes proper notice to all involved, and is approved through the proper governance channels, and it also protects the rights of creditors by using their claims are not impacted.
Chapter 7, Dissolution of Cooperatives. This section outlines the process for voluntary dissolution of a cooperative when creditors are affected. It requires a petition filed with the Cooperative Development Authority, outlining claims and demands against the cooperative, and a resolution by 2/3 of the members from voting rights. The CDA then sets a date for objections and conducts hearing before issuing an order dissolving the cooperative and directing the disposition of its assets. Section 67. This section details the process for involuntary dissolution of a cooperative by order of a competent court. This can occur due to the violation of laws, regulations, or bylaws or due to insolvency. Section 68. This section outlines the grounds of suspension or revocation of a cooperative certificate of registration by CDA. CDA is Cooperative Development Authority. These grounds include obtaining registrations by fraud, operating for an illegal purpose, violating the code or bylaws, failing to operate cooperatively, and failing to meet the minimum member requirement. Section 69. This section addresses dissolution of a cooperative for failure to organize or operate. If a cooperative does not commence business within 2 years of registration or ceases operation of 2 consecutive years, the CDA can strike its name from the register, effectively dissolving the cooperative. Section 70. This section explains the liquidation process for dissolved cooperatives. The cooperative remains a body for 3 years to set its affairs, dispose of property, and distribute assets. So, during those 3 years, pwede nang isettle yung mga affair, i-dispose of property at ma-distribute yung kanilang asset. Parang pinakamapaghahanda para ma-dissolve yung cooperative. Next, it can convey its property to trustees for the benefits of members, creditors, and other stakeholders. Any undistributed assets go to the affiliated federation, union, or association. So, Chapter 8, Capital, Property, and Funds. For Section 72, na-outline sa kanya ang capitalization of cooperative and the accounting procedures. Section 73. This section lists the sources of capital for cooperatives, including member share, capital loans and borrowings, revolving capital, subsidies, donations, and grants. So this section involves the share capital. Pinapakita yung mga ginamit na pera para dun sa cooperative. Section 74. This section sets limitation on share capital holdings by individual members, restricting them to a maximum of 20% of the cooperative's total share capital. Itong section na ito yung pinaka-nagli-limit sa hinahawak ng bawat individual na membro sa 20% lang ng total na asset na hawak ng cooperative. Kasi nga naman, pag sumubra na dito, parang nagiging mas powerful na yung ibang members ng cooperative. Section 75. This section governs the assignment of share capital, contribution, or interest, requiring 1-year holding period, approval by the Board of Directors, and assignment to cooperative, a member, or a person within the cooperative's membership field. Section 76. This section sets limit on the interest rate of a share capital, which cannot exceed the normal rate on investment as determined by the CDE. Ito naman section 76, siya yung nagsiset ng limit ng interest rate para dun sa capital, para hindi siya lumampas sa normal rate. Kung hindi, mamakikinabang lamang ay yung humahawak ng capital. Section 77. This section defines the term share and explains the concept of share capital in a cooperative. Ine-emphasize dito sa section na ito ang kahalagahan ng pag-share ng capital at kung saan bawat membro ng cooperative ay tulong-tulong na nagbibigay para makaipon ng capital. Section 78. This section allows cooperatives to impose fines and unpaid subscribed share capital subject to the CBA guidelines. Section 79. This section outlines the permitted investment options for cooperative capital, including shares, debentures, and securities of other cooperatives, reputable banks, government securities, real estate for cooperative or member use. Section 80. This section describes the revolving capital mechanism, allowing cooperatives to defer patronage funds and interest on share capitals to strengthen their capital source. So, move on tayo sa Chapter 9, Audit, Inquiry, and Members' Right to Examine. Section 81. This section mandates annual audits for cooperatives, requiring an independent auditor who is a member of a recognized professional accounting or Cooperative Auditors Association. So, dito sa section na ito, pumipili ng isang independent auditor para ma-manage yung funds ng cooperatives. Section 82. This section specifies the contents of the audit report, which must include a statement of assets, liabilities, earnings, expenses, net surplus, losses, and bad debts. Dito naman sa section na ito, pinakikita yung audit reports, yung mga kagastusan at saka yung mga statement ng pinagkagamitan ng pera ng cooperative. Section 83. This section provides protection for auditors from defamation claims as long as their actions and statement are made in good faith. Itong section naman na ito ang nagbibigay ng protection para sa mga auditor ng cooperative kasi maaari nga silang sisihin dahil sila yung nakakalculate ng pera na hawak ng cooperative. Ito ay as long as their statements are made in good faith. Ibig sabihin, hindi sila kumukuha ng pera mula din sa budget. Section 84. This section establishes the right of members to examine cooperative records during business hours, including the right to request copies of excerpts. It is also outlining penalties for officers who refuse to access the records.